Yes, good morning, Mr. Hewitt.
Good morning, my lords. I appear in this matter with my learned friend Mr. Windle for the Appellant Revenue. My learned friend Ms. Shaw appears for the...
Yes. Well, can I thank everybody for accommodating the court in sitting a little bit early. It just moves the court day half an hour. Half an hour up. We'll have our normal break between 1 and 2 if we need to go into the afternoon. And if anybody feels the need for a break in the mid-morning, they could please indicate. But otherwise, we'll press on.
Yeah.
Thank you.
Yes. It is, as you will have seen, my lord, quite a short point.
Yes, it's a nice point. Yes.
Yes. It concerns this appeal concerns a tender support vehicle in particular, which is referred to as a TSV in the papers, called the Borgsten Dolphin, which I shall refer to as the Borgsten throughout. Just to give a little bit of flavour, you may have seen this already. You can see a photograph, a great photograph on page 4 of the supplementary bundle. That is the Borgsten on the left, connected up, looks like, to the Dunbar, which is the drilling rig.
Yes.
And you can also, thereafter, you can see plans of the Borgsten on the following pages, which shows the accommodation and the other things that it has on it. Now, the services that are provided by the Borgsten are set out in the First-tier Tribunal decision at paragraph 23. If we might just look at that, just to write ourselves.
Yes.
Yeah, and you can see the list in paragraph 23 of the various services.
Well, the service is really at 26.
They're really 26, yes, exactly, from 23 to 26. And it's the mud, which is not actual mud, but a chemical substance, and then these other facilities, and a heliport and accommodation. Before going into the details of the provisions, could I just give a sort of overview of what we see as being the essential features of the appeal? The first important fact is that the Borgsten provided accommodation, you'll have seen, for its own crew, who were the ones who were providing these services, and some of the crew of the Dunbar, who were working on the Dunbar drilling for oil. The Borgsten crew, I understand, none of them were offshore workers as defined in the legislation, because they didn't, in this case, I think it's the case, that none of the Borgsten crew worked, in fact, on the Dunbar.
Where is the definition of offshore workers?
Well, I'll come to that.
We'll come to it.
I was just going to assert that for the moment.
Yes.
I'll show you. The Dunbar crew, however, are all offshore workers. They carry out the drilling work. The question is whether the use, a question is whether the use of the Borgsten to accommodate the Dunbar crew members is incidental to the uses of the Borgsten, which are provided by the Borgsten crew, because the former is, according to the FTT, perhaps less important. I'm not quite clear. We'll come to that when we look at the decision. But in some way, there is a relationship between them, that the accommodation is lesser in some way than the services that are being provided by the Borgsten to the Dunbar. I say it's not clear because you'll see that the First-tier Tribunal don't tell us very clearly what criteria they are actually applying in this test. So we say that the provision of the accommodation is not incidental because it's not connected in any way with the supply of the services, the uses of the Borgsten. And that's why it's important that we're focusing on the crew of the Dunbar who are being accommodated on the Borgsten, not the crew of the Borgsten. And we say that if I was to say that I use my laptop to write a shopping list, and I also use my laptop to write an opinion, it wouldn't be a natural use of language to say that one of those uses was incidental to the other. They're entirely separate uses. Whereas, your Lordship's notes that you're making now, using your pen and paper, would be, in my submission, potentially incidental to your use of your laptop to write the judgment in this case. The notes don't have any independent use. They're part of the process. They're in furtherance of the process of writing the judgment. So we say that's the distinction. So with that introduction, can I then take you to the provisions? And I'd like to start with some of the history of the enactment of these provisions, because they went through a number of stages before they were finalised. And you can see in the authorities bundle at tab 4 on page 34, starting on page 34. This is the autumn statement from 2013, which of course will relate to what became the Finance Act 2014. And if you turn to page 36, you will see this is the announcement of these provisions, and it's the third bullet point on 1.302. The statement announces action to prevent offshore contractors who lease equipment to oil and gas operators from using associated companies and tax havens to minimise their UK tax bill. And it's further explained on page 48 at paragraph 2122, where it says the government will cap the amount deductible for inter-group leasing payments for large offshore oil and gas assets, known as bareboat charters, and introduce a new ring fence to protect the resulting revenue. The government will consult with industry in early 2014. So at this stage, the proposal was that all leasing of these assets to associated companies would be caught by the provision. Now, there was consultation, perhaps that's a polite way of describing it, some consternation, I think, amongst the industry at that. And the first proposal, so this is if you like the second stage. Sorry, I want to say that no, as far as we can understand, no draft provisions were ever published on this initial proposal. I think possibly because it was realised that would be going too far. And so the provisions that were published come later. I'll just come to that in a moment. The next document is a document of 19th March 2014. And this explains on page 43 what the problem was and what was being proposed at that stage. It says, as announced in the autumn statement, the government is concerned about the use of bareboat charters to move significant taxable profits outside the UK tax net, and has been holding informal discussions with industry. Legislation will be introduced during the passage of the Finance Bill 2014 to cap the amount allowed as a deduction for these charters to companies that provide drilling services or accommodation services. So at this stage it was being limited to drilling and accommodation, as opposed to there are many other types of craft which operate in the North Sea in relation to oil exploration and do other things. I mean, I'm told heavy lifting is one example. There are crafts who do that. But anyways, there's a number of different types. And going to say the cap will be calculated by reference to the historic capital cost of the asset, which is subject to the lease, and will consist of a proxy for capital expenditure at a rate of 4% per calendar year. That's an amount to represent possible finance costs, which will be set at 5% on borrowing part of cost, plus an additional 1%. And then it goes on to say legislation will also be introduced to provide a new form of ring fence applicable to the composite activity, which is the subject of this measure, whilst profits within this ring fence will only be taxed at standard corporation tax rates, not the higher rates which apply under the Oil Taxation Act. Those profits will no longer be able to be reduced by other tax reliefs derived from activity outside the UK continental shelf. That's what they mean by ring fencing. And you can't set off expenses or losses from other activities against them. I hope it's obvious what the problem was that was being addressed here. it was where these assets were being leased from associated companies, particularly in tax havens. I think that's what they just talk about in the next document. At what was perceived to be, at least by the revenue, at high rates, which meant that very little of the profits that were being made in the UK were being taxed in the UK. They were going essentially by way of a deduction for the rental payments to the other country in which they were not being taxed, or taxed at a very low rate. And that's I think made clear in page 46, which is the first page of the technical note of 1st April 2014. Which says, at Autumn Statement 2013, the government announced a measure to ensure that more of the profits made by offshore contractors in the UK are subject to UK tax. Offshore contractors have used intra-group payments to move up to 90% of operating profit made in connection with activity on the UK continental shelf. This measure was part of a £9 billion package of measures addressing unfair tax outcomes. The government consulted informally with affected businesses, representative bodies and advisors on the measure during February 2014, and based on the evidence received during the consultation made a number of changes. And you can see the changes. The measure will now only apply to drilling rigs and accommodation vessels. The cap on the bareboat deduction is increased to 7.5%, and the pro rata calculation is based on the worldwide use of the vessel. The legislation will operate by capping the tax deduction available for a bareboat or similar leasing payment to an associated person where this arises as part of a composite service. The legislation also ensures that the profits arising from that service are not reduced by unrelated tax relief. That's the ring fencing. And the draft provision is found on page 51. Which is clause 356 LA, which is going to be inserted in the legislation. And I'll come back to looking at the actual provision, but the difference was, there's two differences. One is in 2B little Roman 2, on the second line, the word "are" structure becomes another structure in the actual legislation. But more importantly, perhaps, the provision that we are arguing about today didn't exist at this stage.
Just as
at all.
As a broad question, to what extent are we entitled to consider all of this? It's interesting, obviously, but I mean, in the end, the Act says what the Act says.
It does. It's perhaps useful to see how it developed when it was being enacted. But
well, it may be useful, but
yeah, it may not matter to the construction.
No.
What may be useful background is what the purpose of the legislation
I mean,
was.
I'm interjecting this just to to say that although I think my lords have got all the material you're reading, and I've been listening carefully, it hasn't been included in the electronic version of the authorities bundle. So that doesn't matter because I'm in general of the view that this is maybe interesting context, but it's not relevant to our task.
It does actually appear in the supplementary bundle as well.
All right.
So you will have it. Right, yes. Okay, sorry.
It really doesn't matter because the tale that you're telling is perfectly understandable without having to
without
look at all
having to
this.
see it. Yeah. What it does is make clear what the background was to the legislation, why it was being enacted. What the position was then was that you can see any asset which could be used to provide accommodation would be caught at that stage. There would be no let outs at all. And so the problem with that, we said the problem that the provision which was then introduced was trying to deal with was this. You would often have a situation where you would have a support vehicle, support structure. I think I gave the example of the heavy lifting one, where the crew would be providing the services of the heavy lifting to the platform, to the oil rig. But some of the workers, some of the crew of the support vessel would have to work, at least some of the time, on the rig. And as we shall see in a moment when we look at the legislation, that would make them offshore workers as defined, because they would be working on or from the exploration platform. And the problem with that is that would mean that if you're in a situation where the support vessel crew, some of them were offshore workers, they would be caught by this legislation, despite the fact that all they're doing is providing the services of the support vehicle, not the drilling for oil. And the purpose of these provisions was to catch drilling and accommodation for drilling, essentially. So if you had the drilling rig itself would be caught, but also an accommodation vessel which was accommodating just those who were on the rig drilling would be caught as well. So that was the purpose of we would say the purpose of the legislation. So if we then go to the provisions as enacted, which we are arguing about, which are right at the beginning of that bundle. It's what became Chapter 2 of the Corporation Taxes Act 2010. Chapter 2 of Part 8ZA. And if we could just start at 365N, which is on page 4, at the bottom, because that is the restriction, and then we can go from that to the defined terms. So the section applies if the contractor makes one or more payments under a lease of a relevant asset or part of a relevant asset. And then the total amount that we brought into account in respect to the payment, calculating the contractor's ring-fence profits in an accounting period is limited to the hire cap. And then the hire cap, you can see, and I'm not going to take you through it, but you can see the calculations for the hire cap are in the subsequent subsections. So what it does is it doesn't remove completely a deduction, it just caps it at what is thought to be a reasonable figure. So what is a relevant asset? And a relevant asset is defined in section 356 LA, which is on page 3. It means an asset within subsection 2, and that's the crucial subsection for us, in respect of its conditions A and B are met. There's no doubt that conditions A and B are met in this case. Conditions A is in subsection 5, it's leased from an associated person other than the contractor. And condition B is of the requisite value, which is more than £2 million. So it's subsection 2 that we have to concentrate on. So the asset is within the subsection if it is a structure that, first of all, can be moved from place to place, whether or not under its own power, without major dismantling or modification. There's no doubt in this case that the Borgsten can be moved place to place. And secondly, can be used to, one, drill for the purposes of searching for or extracting oil, or to provide accommodation for individuals who work on or from another structure used in a relevant offshore area for or in connection with exploration or exploitation activities. And those are defined, exploration or exploitation activities are defined in the section above, 365L, subsection 4. Activities carried on in connection with the exploration or exploitation of the seabed and subsoil and their natural resources. I think it is, in short, a drilling rig, but that's roughly what it tended to be. So it's used for those for the asset which is actually drilling, and also for the asset which is providing accommodation for what are defined as offshore workers, those who work on or from another structure. But the definition of offshore worker doesn't depend on what they do, it depends on where they work. And that's why, as I said, the problem arose that without subsection 3, this would catch situations which it wasn't intended to catch. So subsection 3 is a crucial provision. An asset is not within subsection 2b2, that is providing accommodation, if it's reasonable to suppose that its use to provide accommodation for offshore workers is unlikely to be more than incidental to another use or other uses to which the asset is likely to be put. So what you're looking at on the one side is its use to provide accommodation for offshore workers, and on the other side, another use or other uses to which that asset, that is in this case the Borgsten, is likely to be put. And those are the potential uses or the uses that we looked at in the First-tier Tribunal decision.
Could you give an example of a situation, not with this TSV, but with a TSV that was alongside a rig, where the offshore workers on the rig might be accommodated on the TSV in a manner that would be incidental? What sort of situation might arise that would actually allow the taxpayer to take advantage of subsection 3?
The example was the example that I've given. That's what it's aimed at. It's a situation where those who are being accommodated, the offshore workers who are being accommodated, are those who are providing, who are the crew of that vessel, who are providing the uses of the TSV.
Yes. But I mean, could one give other examples where, for example, from time to time it was necessary by chance or because people couldn't travel or for some reason or other, where people overspilled onto the TSV in a way that was not integral to the use of the TSV, but was simply a happenstance?
I would submit yes, that would be covered, but it's not particularly by the incidentals. It's by the likely, because there you wouldn't say it was likely.
Yes, but you might in over a period of time have stuff happens and people have to sleep, and if they ended up sleeping on the TSV, that might not on the face of it lose the taxpayer the benefit of subsection 3.
If it was, as you say, happenstance, some emergency or something like that caused it, then.
So that might be an instance in which that would have some teeth.
But I think it would be because of there are two aspects to this provision. One is the incidental, but the other one is the likely. You have to assess what's likely, not what actually happens. So if it wasn't likely that it would happen.
When do you assess that?
Sorry?
When do you assess it?
Well, that's a good question. It has to be assessed, I think, period by period, and so you would have to look.
So taking the facts of this case,
yes,
this legislation comes into force with effect from the 1st of April 2014.
yes.
So the tax which has been assessed is for the accounting period 1st of April 2014 to 31st December 2014, and then again for the next year.
I'm not actually sure how the transitional provision worked on this. Sometimes it only works in relation to periods which end after it comes in, so for the whole period. I don't know.
I
haven't looked at the transitional provision.
I thought that there was a charge for a 9-month period from April.
Maybe you're right. Yes, in this case, maybe. That's,
and then again for the next accounting year.
Yeah.
So
I think you'd have to look at the beginning of the period. I think.
So on the 1st of April, you ask the question. By that stage, the contract's already been signed, the Borgsten's alongside, it's being used. But you ask, how likely is it that it will be used, for the rest of the accounting period?
It has to be, yes, because it's that accounting period. This provision works by accounting period, so you have to look at it for that accounting period. Things might change for the next accounting period.
So you ask the question again on the 1st of January 2015?
I think you really have. I think you probably have to. It's just the nature of this test, which is a test of likelihood rather than actual fact. So it's not asking if it did actually provide accommodation. It's asking you.
So your answer is the 1st of April and then the 1st of January next.
I think that's the practical way you have to look at it.
But in practice, this case happily doesn't throw up any suggestion that there was any difference during that period. It was a uniform period.
No, I don't think there's any issue in this case about likelihood. I mean, I think
no, but there is an issue as to what extent you look at the actual contract.
Yes.
Which I think is your ground too. And if it's right that under the legislation you ask this question, is it reasonable to suppose that its use is likely? And you ask it at those particular dates, then it will be a relevant fact, will it not, that at those dates the contract's already up and running. And so there is a contract. It's not some future contract. It is that contract which the Borgsten is being used to fulfil.
Exactly. Yeah, no, I agree with that. Well, you have to take account of the contract in assessing likelihood. But in this case, as I say, when you do assess likelihood, then I don't think it's disputed that conclusion would be it was likely that it would provide accommodation for the crew, some of the crew of the Dunbar, which it actually did. And there are a number of factors. There's the contract, there's the fact that they deliberately increased the accommodation, the fact that there's not enough accommodation on the Dunbar for its crew. Those factors would be taken into account. And I don't think there's any dispute that it would be likely that it would. Assessing it at 1st of April or whenever you assess it, it would be likely that that would happen. The question is whether that's incidental to the provision, the uses of the Borgsten, provision of accommodation to the crew of the Dunbar.
I'm struggling at the moment with understanding what difference it makes that instead of the legislation saying that an asset's not within blah 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 if its use is no more than incidental, and saying if it's reasonable to suppose that its use is unlikely to be more than incidental, what difference does it make?
Well, it makes a difference because the starting point is if it can be used, then if it can be used, you're potentially within it. Then you have to look at subsection 3, and if it didn't say unlikely, if it was if it didn't say unlikely, you still have a reasonable to suppose, I suppose, which is an objective test. But I think the danger there is you would actually have to just look at what actually happened.
What difference does it make? I can't at the moment see when it would make a difference that it uses this slightly unusual test of what it's reasonable, whether it's reasonable to suppose that something's likely, as opposed to a much simpler test of whether something happened.
Well, there's a big difference between whether something happened and whether it's reasonable to suppose it's likely. And one of the differences comes in when you have unexpected, perhaps, events happening. Because then you would have, it would have been used to accommodate offshore workers, in fact, because of some emergency or something.
So suppose
you wouldn't come within this.
Suppose the Borgsten was moored alongside the Dunbar in circumstances where everybody who worked on the Dunbar could be accommodated on the Dunbar.
Yeah.
And that's what everybody would have expected to happen. But it turned out that there was a fire on the Dunbar one day, and for a period of a week, some of the accommodation couldn't be used. So you had to house Dunbar workers on the Borgsten, which has spare berths. You'd say, although it was in fact used to accommodate offshore workers, looking at it at the beginning of the period, it wouldn't be reasonable to suppose that it was likely to be.
It's not intended to catch that kind of.
Yes. Okay. Well, now I understand the
Yeah.
difference. Yes. Thank you.
And just before you move on, reversing to my Lord's question about the unexpected provision of accommodation, sort of thing. For what it's worth, I see the FTT cites what at any rate was said in the Oil Taxation Manual at the time in paragraph 164. And that says situations where the provision of accommodation is likely to be considered incidental, and various things are given, including the unexpected provision of accommodation as a result of adverse weather conditions. So, according to the manual, that's catered for by incidental.
Yes.
Whereas you say that's probably.
I wouldn't agree with. I wouldn't.
Yes, I see.
Agree with that as a matter of law.
Yeah.
It doesn't matter whether it's incidental or likely.
Yes.
But you say that in this case, on your submission, the longer formulation that my Lord has been interrogating sort of collapses in on itself, because not only is it what was intended to happen, what did happen, but one can say at the beginning of each period, it's the likelihood was that was what it would be.
In this case.
Yes.
Yes.
So in this case.
In this case.
So that this case is on your submission. I appreciate there may be others. That leads to no difference of outcome, because the focus is on a different part of the subsection.
Yes.
Which
Exactly.
is what incidentality means, if that's a word.
In my submission, the significance of the contracts and significance of the fact that it they requested further accommodation to be built beyond what was necessary for the crew of the Borgsten all just goes to the likelihood.
So if you took a different situation whereby for some reason the kit didn't lend itself to adaptation in the way that happened in this case with the Borgsten, you still obviously needed to have the people in order to run the Dunbar, and you'd simply got another piece of kit in the form of a flotel and put that alongside, so that you had 3 rather than 2.
Yeah.
Clearly, the flotel would not attract the relief under
The
3.
flotel would be caught by the provision.
Would be caught by the provisions
Exactly.
under
Yes.
2.
Absolutely.
And so, in reality, your case is that you can't get round that by putting the 2 together.
Exactly. Yes. Precisely so. Precisely so. And that's not what subsection 3 is aimed to allow you to achieve.
Can I summarise it in this way? This has been very, very helpful interchange. Picking up my Lord's point, in the present case, what happened in fact is exactly the same as what it was would have been reasonable to suppose was likely to happen, looked at the beginning of each accounting period.
Yes.
Yes.
Yes. As you're aware, we say the primary meaning of incidental to when you are comparing whether one use or whatever is incidental to another is that explained by the Vice Chancellor in the authority, which mercifully one of the shortest authority bundles I've ever come across in any appeal in my.
Well,
mine was
even shorter.
Well, exactly. Well, and the irony is that 2 of the documents which we added in weren't necessary because they were actually in the supplementary bundle. I hadn't realised already. So in fact, we could have had a shorter one. And that was the original version. You're right, my lord. It was really very short. We say it is that a use which serves no independent purpose but is used to further another use. That is the natural meaning. And that is the meaning in the context of this subsection.
Sorry, did you want to take us to the Vice Chancellor?
I could do that now, yes, it certainly will. Then I'll come back to this provision. It's the second tab. Again, the facts of this case are relatively straightforward. You can see from the head note, this is a case where a pilot was seeking to claim he was not resident in the UK. And you can see from the facts that he made a total of 811 takeoffs and landings in all countries. This is in the head note, of which only 38 were in the United Kingdom, came to the United Kingdom. And most of the latter were for periods of 1 hour or less. So the question was whether, under the provision, which is set out on page 11 of the bundle, the very end, if you look at the section 11, which is in the middle of the page, where an officer in employment is in substance one of which the duties fall in the year of assessment to be performed outside the United Kingdom, the Vice Chancellor says that he was going to skate over that provision, that part of the provision, as the Tribunal, the Special Commissioners had, but except that it was satisfied. They shall be treated for the purposes of this section as so performed any duties performed in the United Kingdom, the performance of which is merely incidental to the performance of the other duties outside the United Kingdom.
But this is a carve out of sub 2, isn't it?
Exactly. Yeah.
Which was uncompromisingly
Yes.
no part
No
of
part
the
of it.
trade profession performed in the UK.
Yes, exactly. And so what the Vice Chancellor said, if we turn over to page 14, the paragraph beginning at F is the one in which he discusses the first limb and says that in the end he's going to skate over it. He then says the sole question is whether the second requirement is performed. The second requirement is, as I've said, that any duties performed in the United Kingdom shall be treated as performed outside the United Kingdom if their performance is merely incidental to the performance of the other duties outside the United Kingdom. The expression merely incidental is a striking one, and effect must be given to the natural meaning of the words. The words merely incidental to are upon their ordinary use apt to denote an activity, here the performance of duties, which does not serve any independent purpose, but is carried out in order to further some other purpose. In the present case, the duties performed by the taxpayer, apart from his duties on the ground at Sheeple, mainly consisted, putting it shortly, of taking a plane up at Sheeple, flying it to wherever its destination was, and bringing it down. In the case of the flights from Sheeple to some destination, normally in America, on which there was a stop in England, his duties consisted of taking the plane up to Sheeple, flying it to England, bringing it down to Heathrow or elsewhere, and then taking it up again and flying it again to the next destination in America. With the best will in the world, I found it impossible to say that the activities carried on in or over England are merely incidental to the performance of the comparable activities carried on in over Holland, or in or over the ultimate destination in America. The activities are precisely coordinate. I cannot see how it can properly be said that the activities in England are in some way incidental to the other activities. Going back to the words of the section, when one asks, what exactly are the other duties outside the United Kingdom to which the performance of the duties are incidental? No satisfactory answer can be given. The other duties are simply coordinate duties.
What does coordinate mean?
I think it means parallel, perhaps. One is not furthering the other. They're both independent. That was what the flavour I got of it. And in this case, they're the same kind of duties. In this case,
Well, I think numbered alongside. I mean, if one goes to the original
yes,
sense of coordinate, it would mean that the duties in the UK were, as it were, numbered alongside the duties outside the UK.
yes, yeah. And then if we just the next paragraph, if we miss out the next paragraph, which is discussing Mr. Pinson's argument, and then the following paragraph F. Again, I think it's impossible to construe subsection 3 in the way in which it was sought to construe it in the taxpayer's contentions in the case stated, as indicating merely relative short periods of employment in the United Kingdom in relation to the period of employment outside the United Kingdom. It would have been quite simple for the section so to provide, and it may well be that if the condition were imported only by the expression in substance, that would be the result. But the second requirement was expressed in quite different terms and cannot, I think, be treated as referring merely to what had been described as a quantitative and contradistinction to a qualitative basis. In order to avoid misunderstanding, I should mention it's accepted on behalf of the Crown that a landing in the United Kingdom by reason of an emergency, such as weather conditions or mechanical trouble, might be regarded as incidental to the performance of duties outside the United Kingdom. I should have thought that was clearly right. Again, one might have the position of a de minimis, a single landing. Again, I express no view of the position of a pilot's normal route did not touch the United Kingdom, but on one or two occasions he had landed in the United Kingdom while acting as a substitute for some other pilot who was ill. There might well be borderline questions. But here one has a regular series of scheduled flights involving a landing in the United Kingdom, and as I already said, I find it impossible to say that these landings are merely incidental to the performance of the duties outside the United Kingdom. It's tempting to say that all of the duties performed by a pilot are incidental to the purpose of transporting passengers from one place to another, but that approach is clearly would not help here. What is to be shown is that the particular duties in the United Kingdom are incidental to the performance of other particular duties outside the United Kingdom. Yeah, it says it's not a question of fact, it's a question of construction of section 11. So what he was saying was it's not a question of looking at the relative sizes, I'll use a neutral term, because you can see that the UK elements were really quite small compared to the total duties that he performed.
No, and in 1 year where it was de minimis, the taxpayer was excused.
Yes, if it's de minimis, but it was 38 out of 811, which is just under 5%. But that's not the approach which the Vice-Chancellor took.
Yes, in 1961 to 2, there was one takeoff and landing in England. So
Yes.
the Revenue didn't try to charge him for that year.
Yes. And similarly, I suppose if you apply that in the present case, you might say if there was one stay over the year, that might be de minimis as well.
Right, so you say although the words are not identical, that gives a flavour of the approach that might
Yes,
probably
we
be
would
taken.
say a use being incidental to another use is the same as the performance of duties being incidental to other duties. Yeah, they're both operations, if you like, uses, performance of duties.
Is there any difference between unlikely to be more than incidental and not merely incidental? Merely incidental.
Yes, we would say there's nothing really magical in the word merely. And it did seem to be the word incidental that the Vice Chancellor was concentrating on. But unlikely to be more than has the same kind of flavour as merely, we would say.
I must say, just understanding the provision, I would have found it easier to understand if it had said likely to be merely, rather than unlikely to be more than incidental.
Yes, if it said merely incidental. Yes. Well, the draftsman can take note. In my submission, that's not the significant word in the phrase. So if we go back to the legislation on page 3, we see there's another indication here. But first of all, it's whether one thing, one use, is incidental to another, and we say that is the context in which the approach, the meaning given by the Vice Chancellor, which we say is the most natural meaning of incidental, should be applied. But the other point is that it's unlikely to be more incidental to another use or other uses. So it's not necessarily comparing the use as accommodation to all of the uses of the Borgsten, all the what are called permitted uses. If it had been intending to do that, it would have said something like, it's unlikely to be more than incidental to the use or the uses. And the approach of comparing size really only makes sense if you are comparing it to all of the uses of the Borgsten. Whereas if you were asking the question, is it incidental in the sense that the Vice-Chancellor was talking about, then it would make sense to ask whether it's incidental to one of the uses. Because it might be incidental to one of the uses, but not to other uses, which are, you know, it might not be incidental to those. So you're really asking the question, is it incidental to another use that's being made? For instance, the crew that are there may provide one use, but they may not in some way provide the other use. You may not say it's incidental to that use. For instance, the provision of the helipad might be one. I don't know. My point simply is this is the most natural way to express it if you are looking at the kind of test that the Vice-Chancellor is proposing, rather than the kind of test which it seems that the First-tier Tribunal were applying, which was to look at the use as accommodation and then compare it to all of the uses to which the Borgsten was put, and to ask the question, was that incidental to all of those uses in the sense of being whatever, more important, less important, bigger,
just
small.
trying to think around that a moment. The FTT says it's incidental to the provision of the TAD services and or the provision of accommodation to the Borgsten's crew, does it? Something like that. Am I getting that wrong?
But we'll come to the FTT decision. Actually, that was probably
for the moment, could I just
next
check
one.
what it is you're saying, that we have conveniently at paragraph 26 of the FTT, which we looked at before, the three main range of drilling support services that were required. There's the mud, there's the general support services and facilities, and there's the helipad. And so in your analysis then, are those the uses
to which the asset
must be,
Borgsten
where we're considering the incidental
yes,
nature
yes,
of the accommodation to those uses?
exactly. It's those uses, because it's the uses to which the asset, and the asset we're talking about in this case is the Borgsten, not the Dunbar.
Right.
So it's a use to which the asset is likely to be put. And
Right.
Again,
And so-
I think that's the same as the uses it actually was put to. Was
Yes.
Sorry, go on.
And I mean, I don't want to oversimplify or mistake what your submission is, but if one compares the provision of accommodation for whatever it was, 60 or so Dunbar workers on a regular basis, again, I may not have that exactly right, but the sort of picture one has, with the other uses of the Borgsten, which are in paragraph 26, what you say that those are obviously not incidental to the other
Yes,
Borgsten activities.
because the crew of the Dunbar, all they're doing is sleeping and eating on the Borgsten.
Right, and so from the point of view of the Borgsten, they might as well be on a flotel next door.
Yes, exactly. They're not doing anything on the Borgsten. They're not working on the Borgsten. They're not providing the uses.
Okay. The risk of confusing everybody. Can I just go back then? So the FTT says that unlikely to be more than incidental to the use of the Borgsten to provide TAD services to the Dunbar and or to accommodate DDL personnel working on the Borgsten. So they're not proceeding on the basis that you look merely at the TAD services.
Yeah.
Yes, and so this paragraph are you putting
And
that?
this is 176.
Yes. No, they don't, in my submission, they don't apply the correct approach in a number of occasions. And I think that's probably one of them.
176 is where they come to their conclusion.
Yes,
So it's incidental to the TAD services and or the accommodation of the Borgsten crew. Now,
yes, well, I suppose in a sense, it is accommodating the crew, but that's not one of the services. I mean, the accommodation of the Borgsten crew would be part of providing the services. So I don't think.
I'm just trying to relate it back to what you were saying, so I understand, so I'm clear whether I understand what your point is. So the statutory test is, I'm going to gloss it, likely to be merely incidental to another use. And the FTT is envisaging two other uses: the provision of TAD services and the provision of accommodation to the Borgsten crew. And do you say that the second use is not a relevant use, or what is your position?
Well, my first response would be it doesn't matter, because providing accommodation to the Dunbar crew is not incidental to that anyway. But I would say no, that's not one of the services that are being provided. That's perhaps one of the ways in which they provide the service, by having the crew and providing accommodation.
Yes, I see.
So we can ignore the Borgsten crew for practical purposes.
They're the ones who are providing the Borgsten services.
Exactly. So they're not the ones that we're concerned with.
I'm not sure I understand this submission, because go back to the wording of section 356 LA3. It doesn't refer to providing services. It refers to whether it's incidental to another use to which the asset is likely to be put. And Borgsten was used to accommodate Borgsten workers. So that is another use to which it was put and was likely to be put. And my Lord's question is the FTT right to say that using it for accommodating Dunbar workers could be regarded as incidental to using it to accommodate Borgsten workers?
Yes, I see.
And your answer is no.
No.
Yes.
And I follow your answer is no. A moment ago you gave the reason for that being that the Borgsten crew were not of themselves a service, they were providing a service. But if you're looking at how the Borgsten is being used, is that a sufficient explanation for your point? I mean, the Borgsten is being used in that way, so
it could be seen as that. Although I'd always read that as being the way it was being used to provide its services. But I can see the point. You might include them. Yes.
I mean, I can see
doesn't matter.
You might then protest on a different basis, which is, I mean, jumping around. So suppose you're undertaking an office development and you provide a car park for the office development, and you think, well, the ground floor needs 10 car parking spaces, and then the upper floor needs 20 car parking spaces. And so you build a car park with 10 car parking spaces for one bit of the accommodation and 20 car parking spaces for the other bit of the accommodation. The car park is being used for both purposes, but you wouldn't say that the 10 spaces were subsidiary or incidental to the 20 spaces.
No.
That's like the Vice-Chancellor's case, where taking off from Schiphol and landing in New York is no different from landing and taking off at Heathrow. I mean, you can't say one is. That's what I think he means by coordinate. They're the same. They're doing the same thing as part of the overall service.
Yeah.
You're not saying that what you're really doing is taking off in Schiphol and landing in New York, and landing in Heathrow is just incidental to that.
Yeah. Yes, that's right. I agree. And I mean, thinking about that, it may be that it's right to put the accommodation in, because they do refer in the opening words to the use to provide accommodation for offshore workers. So that does seem to be anticipated to be a use. I think to be fair,
Yes,
I would
that's
accept
what I
that.
mean.
Yeah. So I think I was proposing now, having looked at the provision, to take to the FTT decision.
Yes.
Because although two of our grounds, as you will have seen, formally this is an appeal against the Upper Tribunal's decision, and we have to show the Upper Tribunal erred in law. But I accept. I think the reality of these kind of appeals is that you have to look and see whether the First-tier Tribunal erred in law, because if they didn't, then whatever the Upper Tribunal said, then they would be justified in dismissing the appeal. So I'm happy to concentrate on the First-tier Tribunal decision. But we do lay down a marker that the two grounds which relate to the contract, but also to the question of whether something is required. We do take issue with what the Upper Tribunal said, and I'll perhaps come on to that when we look at the relevant passage.
I think the authority of this court, that in an appeal such as this, the real question is did the FTT get it wrong?
Yes, I think that's right. So that's why I'm going to, yes, exactly why I'm going to concentrate on that. So if we take up the FTT decision, it begins on page 99, paragraph 10. And it starts with an introduction, and then there's a discussion about the evidence, which I'm going to look at. And they make some sort of formal findings of fact in paragraphs 19 to 22. And then we have 23 to 26, which we've already looked at, which are they recite the various services. And then there is a passage about the request for support. And again, I'm not going to go through that. Just to note, in paragraph 33, you see what actually happened. That DDL was awarded the contract, and that the base rate at that stage was $202,000 per day. And then, if we look at paragraph 37, we have a description there between that and 34 of the Borgsten physically and its crew. And then in 41 it says, during a drilling campaign there will be personnel working on the platform and a TSV. Some may work on both, some only on one. Everyone requires accommodation. This may be on either the platform or the TSV. And this is a reference to the point I was making, that there are people who would be working, who might be crew of the Borgsten working on the Dunbar. My understanding is, from looking at the other findings, that there were no such people in this particular case, but that doesn't matter. It recognises that can happen. And then there is a discussion about the accommodation and the various activities. And it says at 45, the Borgsten was operational and fully crewed throughout the pre-drilling phase. Once the Borgsten was in position, it was connected to the Dunbar and kept in the constant state of readiness. And in 46, there was little difference from the day-to-day activities on board the Borgsten during the pre-drilling phase and the fully operational phase.
Just going back to 42, if you were a DDL person working on the Dunbar, you'd be told which structure you would be sleeping on by the operator.
Yes. Yeah, yes. Sorry. We'd have to be told at some point, otherwise we wouldn't know where to go. Yes. Sorry, you were...
No, I was only just, you didn't touch on 42, but the operator would be expected to decide where to accommodate other personnel.
Oh, yes.
But that's not the DDL personnel, that's the total personnel.
Total personnel, which seems to be some of which worked on the Dunbar and some of which worked on the Borgsten, as far as I understand. Total personnel.
If one takes away people who are just Borgsten crew, who are there to operate the Borgsten, and one's considering the totality of the operation, all the people who are there in order to service the Dunbar would either be accommodated on one structure or the other, depending upon the availability of accommodation and no doubt other factors that were...
Yes. And presumably they would have to be told or choose at some point where they're going to sleep.
Yes.
Say, otherwise they wouldn't know where it was. Yeah. And the DDL personnel there's a reference to them in paragraph 53, where they say we already referred to the fact that Borgsten and his own crew who are either DDL employees or subcontractors, including for this purpose employees of the subcontractors. We refer to these personnel as DDL personnel. So that's, even though they're not necessarily, none of these were offshore workers as they were sleeping and working on the Borgsten. That's why I said it didn't seem to me that there were any offshore workers on the Borgsten in this particular case. Although there could be in other circumstances. And then there's a total personnel. There were also personnel provided by Total. Whether they were Total's employees or subcontractors, we refer to these personnel as total personnel. This terminology refers to the employer, contractor, or the individuals concerned. It does not describe where they were working. Individuals in the category of total personnel could work solely on the Borgsten, solely on the Dunbar, or on both. Only those total personnel who worked on or from the Dunbar could be offshore workers. But we'll see later on that the First-tier Tribunal applies the test, or at least seems to be applying it to the total personnel for some reason, rather than the offshore workers.
You mean the totality, including? I think Ms. Shaw in her skeleton puts numbers on the total personnel who were on the Borgsten.
Some of them were not offshore workers.
Yes, I thought.
Yeah. And then we have various, then the decision goes on to talk about, under the next heading, accommodation of different types of offshore vessels and the Borgsten, comparing different kind of vessels. I don't think that's particularly relevant, and the Tribunal didn't find it particularly relevant. But there is a description in paragraphs 63 and 64 of what was happening on the Borgsten. And you can see there, Sodexo, this is paragraph 64, was the service provider for the Borgsten, responsible for catering, laundry, housekeeping, cleaning in the shop. Then there's a contract, there's an agreed scale, and there's also a welcome leaflet, which we have in the supplementary bundle. It begins on page 10 of the supplementary bundle. And we can just look at one aspect of it, which is, I don't know, interesting. So this is what you would get if you were going to be accommodated on the Borgsten. It just tells you all about the facilities on the Borgsten. And there are telephones at that stage. I'm not sure whether that's because there was no signal there or what. But there's also lunch on the second page, and you can see that there are different shifts for different personnel. 11 to 11:45, TSV residents working on TSV, and then the KCA RDS stock personnel and the Cape and other Dunbar workers.
Do we need this level of detail? I mean,
it's just to point out that there are these. You can see the different classes of workers who were accommodated on the.
I see.
And they, for some reason, they had different lunch times, presumably to do with the shifts or whatever. And then we have the contract, which is set out in some detail, which does refer to accommodation. You can see that on paragraph 75, along with a lot of other things. I think it's fair to say, if you just look at the contract, there's far more detail about the other matters than there is about the accommodation. It's fairly straightforward. And going to the point about what would be likely, paragraph 81 records that it was clear that Total expected and required that the TSV providing the TSV drilling services would have surplus accommodation that could be used for Total personnel. And they accepted the submission, the Shaw submission, that there's very little detail in the specimen contract in relation to accommodation, which is correct. We then have a record of evidence that is accepted, given by the DDL witnesses, paragraph 92 and 93, and the change order, which was increasing the personnel, is described at paragraph 113 onwards. And then the tribunal says at 122, the cost of the works was not insignificant, either viewed in isolation or in comparison to the cost of the conversion project. However, giving evidence, Mr. Brandvold explained that whilst he did not know why Total had asked for this and for this increase from 102 to 120 POB, all that had mattered to him was that DDL could comply with the request and the cost was recovered from Total.
Mr. Brandvold was DDL.
He was, yes.
Sorry,
He's one of the witnesses.
where were you reading from?
Sorry, it's paragraph 122.
122, thank you.
So he's sort of saying it wasn't his business to know why Total wanted this extra thing,
Yes.
but they could provide it.
Well, this is part of the theme that one of the factors which the tribunal seemed to have taken into account in the assessment was the perception, I might say the subjective perception of DDL, of the various witnesses, as to the importance of the accommodation in relation to the other services, which tends to suggest that they're not applying, and we would submit the correct test, which is a fully objective test as to what would be reasonable to suppose. The significance of these objective tests is to exclude this kind of consideration where witnesses are saying, I didn't think this, I didn't think that at the time, I didn't regard it as important, etc.
Is that entirely fair? I mean, it's true that the statute clearly requires, by saying reasonable to suppose, some objective assessment of what's likely. But evidence of witnesses who are in the field, and it's their business, might be helpful in letting the tribunal come to its objective conclusion.
It can in some cases, but if it's simply a witness saying, we didn't regard it as important because we only cared about one thing or another, in my submission that wouldn't be.
No, but if you had witnesses who the effect of whose evidence was, in the industry this is regarded as just a bolt-on, it's not of any significance, it's not really what the contract is why the contract's significant.
If that was the evidence, that might be more relevant.
Yeah.
That
It doesn't go anywhere, this point, because they didn't say we're overwhelmed by the evidence of these executives or managers.
No, but I accept that.
I don't really.
They did seem to put it. It seemed to be some of the things that they took into account.
Yes, but these were witnesses who were quite thoroughly cross-examined. I can't remember how long this hearing took all in, but it seems to me consistently with what my lord's just said is the tribunal is just making what it makes of the challenged evidence.
Yes, well, perhaps we'll just look at what particular thing it was that they said about it, but I can agree with the general point. If we then look at paragraph 126, which is a conclusion about the change, whilst we agree that no distinction was drawn in the initial request from Total or in the change order between whether the berths by Total personnel working on the Borgsten or those working on the Dunbar, we regard the fact that the request was made at all as telling, as is the explanation given. The plan was to increase the number of personnel working on the upgrades to the Dunbar so that the drilling operations could commence more quickly. This is the first occasion on which the evidence addresses the question of who the accommodation made available to personnel was to be used by. The additional 25 berths, i.e. the increase from 40 to 65, were requested so that more total personnel working the Dunbar could be accommodated, i.e. offshore workers.
Yes. Sorry, I reminded myself.
It's
Three-day hearing on the by video.
Yes.
Yeah. Yes.
Yes. So that was their conclusion about the change. It was obviously significant, and they obviously wanted the accommodations required. And then they go on to say, and this is slightly controversial, all personnel working on board the Borgsten and the Dunbar needed to be accommodated on one of those vessels throughout the time those vessels were in the field. Personnel and/or supplies were brought to the Borgsten by helicopter most weekdays, usually twice a day. This is how the crews were changed. But you can see that there was no routine helicopters on Saturdays or Sundays. I think the point they're making is that given the way that things were set up with the Borgsten and the Dunbar and the services that we provided, the accommodation was needed, in the sense that without it they couldn't have carried out the operations that they wanted to. Now the Upper Tribunal seems to be making a point that, well, it's not needed because they could have had another flotel, put it beside it. But really that misses the point. I mean, what we're looking at is what's the significance of the actual uses that were made, and all we're saying is that this use was necessary, just as necessary as the other uses, you might say, to which the Borgsten was put. All of these uses were necessary in order to fulfill.
So it was performing an essential function, albeit that essential function could have been provided in another way.
Yes, exactly. Just as exactly the nature of the function was essential.
Because if you didn't have accommodation on the Borgsten for some of the Dunbar workers, there wasn't enough accommodation on the Dunbar. That was the evidence, I think.
That's right, yes.
So
they couldn't be flown in.
They'd have to be flown in and out every day.
Which was not practical. It was impossible. And indeed, it couldn't happen on Saturdays or Sundays because there wasn't any flights, or no routine flights anyway. I think this is the point that's being made.
Oh, I see. Yes.
But I think I remember reading that it was something like a 2-hour flight. I mean, right about that.
This is
4 hours each way. 2-hour flight. Yes, that's one. Yes, 2 hours there, 2 hours back.
This is east of Shetland Island.
Yes, so it wouldn't have been practical at all to be bringing people every day back and forward for 2 hours in a helicopter.
Flying from where? From Lerwick?
I guess so. Yeah, somewhere.
The hook-up with what we have to decide, as I understand the way you put it, is that the test is not whether something's essential or not, but that it becomes very difficult to think of something that can be both essential and incidental.
Exactly. If I think it comes in if we're wrong about because wrong about our primary argument about what it means. If you are adopting some kind of comparison test, which is what the First-tier Tribunal did, that you couldn't say that something that was essential and they found it was important. We'll come on to that. Could be incidental on any normal meaning of the word incidental. That's not possible. Possible meaning. Yes, so paragraph 127 continues by setting out the different berths, making the point that my lord made, that it was impossible. Sorry, you had to have the accommodation on the Borgsten just because of the numbers.
Yes.
And then if we then turn forward to how they decided the case, beginning at paragraph 167 under the heading Consideration Conclusion.
You've skipped over. There's quite a detailed amount of evidence on how many people on average were sleeping and what sort of people they were. Is that significant?
Well, only because only in that it confirms, if it needed to be confirmed, that it was likely to be required. I think my learned friend referred to it as a sanity check. If you look at what actually happened.
But just wading through all the figures, what's the broad picture? That there are as many people sleeping on one platform as the other of the offshore workers? Or
I'm not sure it's possible to tell. I don't think it's possible to tell because they would be sleeping. They would be there in shifts. I mean, you can tell the numbers that were on each platform at any one time.
Right, but there were substantial numbers of workers on each platform.
Yes.
At all times.
Yes.
I mean, Miss Shaw in her skeleton, page 171 of the bundle, paragraph 4, 15, 16, 17, basing herself on the FTT. I haven't checked the two. Does give numbers.
Yeah.
Yes. I mean, they summarise at 143 the FTT in the pre-drilling. Supports the fact that a large majority of total personnel sleeping on the Borgsten were working on the Dunbar. Pre-drilling phase, which is the first accounting period, I think went up until early 2015. 53 out of 58, and the drilling phase 49 out of 59.
So I think that supports what my Lord said is a substantial number. The actual numbers don't matter.
No, I can see that. The bit I haven't picked up, and were it to matter, Miss Shaw could doubtless tell us, is where the figures for Total personnel working on the Borgsten come from, which Miss Shaw gives. But the overall picture is clear enough.
Yes, and I thought they had said somewhere that there was 40 berths occupied by the crew. They may not have been all total personnel, but the crew of the Borgsten.
Yes. All right. You're going to the conclusions.
Yeah. So, 168. The evidence demonstrates, and DDL accepted, that the Borgsten was used to provide accommodation for offshore workers, i.e., those Total personnel who were sleeping on the Borgsten and working on the Dunbar. The exception requires that we assess whether it's reasonable to suppose that this use was unlikely to be more than incidental to other use. And then they accept Ms. Shaw's submission, the language doesn't focus on an assessment of the actual use. Ms. Shaw submitted the actual usage could be relevant to give comfort or as a sanity check. Consider the actual usage can be relevant to assessing the reasonableness of what's supposed to be likely or unlikely. Both parties noted that there's no definition of incidental. This word should be only meaning something is incidental if it's subordinate or secondary to it. Well, we would submit that can only be right if by subordinate you mean that it promotes the other purpose, not simply that it's smaller in amount, smaller in some way. And then they say that having considered all the evidence, we have reached.
This is the, as it were, at the heart of your complaint about how they got to the outcome that they did. But in particular, whatever one means by subordinate, you say secondary is not an analogue for incidental.
No, and certainly not, because it's quite clear later on. You'll see that they regard it as enough. The use for accommodation was of some importance, etc., had substance, but was secondary, presumably, or subordinate. They decided in some way to the other uses, which one might well say are more substantial on some basis, but that's not the test, we would say.
I mean, this illustrates the danger of using different words to try and explain what is, after all, an ordinary English word, incidental, Because subordinate and secondary themselves are not unambiguous.
No.
If by secondary, I think this is your point, if by secondary you're simply placing things in order of importance, you can have something of primary importance and something of secondary importance, but it's still important and it's entirely independent from the first thing.
Yes.
But particularly if you can't do the primary thing unless you have the secondary people.
Whereas you could support a reading of subordinate or secondary as explaining what incidental means, if what you mean is that the second thing is just supporting the first thing. It's just part of the first thing.
Yes, exactly. Exactly. That's the crucial element which they have not addressed in this decision.
Well, having just said it's very dangerous to gloss the words of a statute, do you want to give us any alternative interpretation of what you say incidental means?
Sorry?
Do you want to give us any alternative exposition of what incidental means?
Alternative to what? Well,
apart from the word incidental.
Apart from what the Vice Chancellor, how he explained it as being, that's the way that we put it primarily. That it is something which is supporting. I mean,
I think he said not an independent end in itself.
Well, it's not an independent in itself, but it furthers the other use. I think that's the way he put it. Something which furthers the other use. So there's got to be some kind of connection between them in terms of one of them furthering the other one. That was the way the Vice Chancellor put it.
Does not serve any independent purpose, but is carried out in order to further some other purpose. That's it. That's your solution.
Yes, and you could use the word subordinate to mean that.
Exactly.
But also
subordinate could just mean of less importance.
Exactly. Yes.
We have examples in the two cases that we're considering, the present one and Robson. But in Robson, the Vice Chancellor contrasted merely incidental with coordinate,
yes.
Which is what he thought was going on in that case. And in this case, the FTT is regarding incidental and subordinate as being equivalents. So, in the end, I'm sure we're likely to be thinking that we should think what incidental means on an ordinary reading of the legislation.
Yes. But we do say that the kind of relationship, without putting it into precise words, the kind of relationship that the Vice Chancellor was thinking of is the kind of relationship that is being intended by this legislation, where they talk about one use being incidental to another use. That is, the whole phrase, the context of it, shows you that that's what it's looking at. It's not saying, you could see if it said the use is incidental, full stop. You might say, well, that just means it's very minor, something like that. That's another possible use of incidental in that context.
I mean, coming back for a moment to the manual.
Yeah.
When they say, you emphasise the likely, but the manual seems to go by incidental, which you're disavowing, I know. But they envisage overflow accommodation potentially being incidental, and that would be on the basis that incidental could mean minor, really.
Yes, but it's not.
Which is not the interpretation.
It's not incidental to the other use, though. I can, as I said, I could see if you just used incidental, and I think on some occasions it is used just as something is incidental. Then there is a possible meaning, I think, but it's a meaning of very minor.
Yes.
Something's incidental. Just something that happens to have occurred.
Yes.
So your point is, it's not just the word incidental, but it's incidental to another use. So it needs to be tied into that other use, rather than just of lesser importance compared to the other use. Is that
Yes, that's my point. Yes. Yes.
So just coming back to my irrelevant car parking example, where you have the car park providing 20 car parking spaces for one office and 30 car parking spaces for the other. Plainly, the 20 car parking spaces are less important than the 30. But you say the 20 car parking spaces aren't serving any purpose in relation to the 30.
Yes, they're not incidental to the provision of the 30. They may be incidental to the provision of the building.
Yes.
Something like that, yeah.
Yes. Right, so,
So-
we're on 170.
Yeah. So that's they then say they bear in mind that the legislation does not specifically require that this other use is a main or primary use. And we say this is quite significant, because this is if legislation was envisaging some kind of comparison, then the kind of language that they tend to use is something like main, whether something's a main. Certainly in the context of purposes, there are very many provisions that talk about something being a main purpose, or one of the main purposes. I'm sure certainly my lord has been involved in cases where that's the issue. So there's lots of different language you can use to where you're making a comparison in size of some sort.
Where do they say that it's not framed in terms of primary use?
170, the final sentence of 170.
Oh, thank you. Yes.
Yeah. So then they say they've considered all the evidence, reached the view that there is a significant amount of evidence supporting a conclusion that it's reasonable to suppose that the use of the Borgsten to provide accommodation to total personnel generally, irrespective of whether they were offshore workers or working the Borgsten, was unlikely to be incidental to the permitted uses. It's slightly strange that they're not applying the statutory test here, which is that you only compare the use to provide accommodation to offshore workers to the permitted uses. They're comparing the total personnel who might be offshore workers or might not be for some reason. And then we have the various things that they take into account. First of all, the contract, the details of the accommodation are very brief, whereas the other services are much more detailed. And then we have one of the subjective things. DDL did not give any significant thought to the use of the accommodation. Now, in my submission, that is definitely a subjective. And then we have 3, having required the 40 berths, there's no mention in the contract of how much use they would make of the accommodation available to it, or who Total would seek to have accommodated under the berths. There was no commitment by Total to use any of the berths. Again, we would say that doesn't seem to be of any relevance to the question you're asking, which is a likeliness of use, likeliness of something being incidental to another.
Well, it might be one thing if the beds were as I think one of the witnesses said, they were there anyhow. But actually, this is the case which they were expanded to be there.
Exactly. Yes. So the fact that the contract didn't commit them to do it we would say doesn't make any difference to the question.
Just coming back to there anyway. I mean, suppose I own a hotel with 50 rooms, and I enter into a contract to provide those 50 rooms to somebody. The fact that they're there already doesn't seem of any great importance.
No,
No.
I wasn't suggesting that. It was a further reason, as I understand you to put it, namely that it's not just they were there anyway, but they were expanded.
They were expanded, but in any event, you're looking at the significance of the use, the actual use, or what was likely to be the use. And so, whether they were there anyway, I would submit doesn't make any difference.
But there is a difference between a contract which says we want to have these rooms available for us, but we'll only pay for them if we use them, and we're not expecting to use them very much. And a contract which says we need to have these rooms available, and we're going to use them. And the fact is, they did use them.
Yes, I'm not sure the contract said any of these.
No, well, I think that's the point the FTT makes. Is it's not something focused on in the contracts. It's not important from DDL's point of view whether they use them or not. They pay for them if they use them.
They pay them, yeah.
But
They pay a marginal cost if they use them. I mean, they're paying for the package.
Anyway, as
Yes.
well, yes, yeah. But they pay only when they use them. But that's simply a matter of flexibility, isn't it? I mean,
Yes.
they don't know how many they're going to use exactly from time to time, presumably. Things change, and presumably you can't plan exactly how many people are going to be on at any time.
No, but your point is, what is much more significant is that Total required through the change order that they be expanded and paid a substantial amount. I think about $4 million to have the extra accommodation put on. They're not going to do that if it's just of no importance to them at all.
Yes, and the tribunal do find it was of some importance. We'll come on to see. So then there's the next point again that we would say is to some extent a subjective point. In practical terms, making available the accommodation was immaterial to DDL because accommodation needed to be available to and used by the DDL personnel. So I think the point being made there is that you had to have the catering, laundry and gym, etc. anyway. So it didn't matter too much that you had more people being accommodated who were using it.
Well, it mattered in the sense that Total required some accommodation, and they were in the fortunate position of having some surplus accommodation.
Yeah. And then the basis on which they agreed to increase the accommodation was that Total would bear the cost of the works, and this did not delay the conversion. Again, that's looking at it from the point of view of DDL and focusing on how important do they think it was, which again we would say is missing the point. And finally, most of the deck space was related to the use of the TAD services, the Dunbar. But I think that's right in physical terms. Mr. Thane's evidence is less than 10% for accommodation, but then you do have to take account further of gym, lounges, galleys, messes.
But this is, you would say, completely irrelevant.
Yes.
I mean, helicopters are bigger than people.
Yeah.
They need more space to
Exactly, yeah.
park.
Yeah. Exactly, you can't tell something's importance by the size of it, significance of it. And then I really don't understand the last point, or the significance of it. They say that it's true that the legislation came in on that date, and the Borgsten was already there. And the activities were largely the same, both pre-drilling and drilling. But I don't really understand the significance of that.
Because these are not just pure findings of fact or summaries of their conclusions. These are reasons in support of their decision.
Yes.
Under 171.
This is the evidence supporting the conclusion.
Yes.
Yeah. But they then go, so the way they structure it is they set out evidence supporting the conclusion. They then deal with value in paragraph 172, which I think potentially can go both ways in some views. And then in 173, they deal with, I would suggest, points against the conclusion. And they mention the request for accommodation. That in 3, Total wanted to have more berths available and was prepared to pay for them. They talk about delays to the work. And then they say the POB logs show the actual use by Total personnel of the accommodation on the Borgsten. They did use the additional accommodation which had been requested and paid for. A large majority of Total personnel sleeping on the Borgsten were working on the Dunbar. This was the case in both pre-drilling and drilling phases. I think this is the point. This is really all you need to know as far as the amounts are concerned, and then the amount that they were paying for Total personnel to be accommodated on the Borgsten. And then in 174, they list some matters which they didn't consider particularly relevant, which I think I agree with. And then in 175, they say the assessment of whether the Borgsten is within 356 LA3 for the accounting period is an issue. does not require us simply to weigh these lists of factors against each other. And I take it from that they mean the factors that they've set out in 171, 172 and 173. This is rather, my submission, rather puzzling, because I'm not quite sure what exercise they thought they were doing if they weren't weighing them. We recognise that taken together, the factors listed at 173 above demonstrate that the use of the Borgsten to provide accommodation to offshore workers could reasonably be supposed to be of some importance. We have therefore had to consider whether this precludes the use from being no more than incidental. We have concluded that it does not. So at this stage they're asking a slightly strange question, which is whether the fact that it's of some importance precludes it from being no more than incidental. And they say incidental does not need to be confined to uses which are trivial, can capture uses which, while being desirable, sought after, or even important, are nevertheless, when viewed in context, secondary or less important than another use.
So that's repeating the error that you say came in at 170.
Yes. And then, as if by magic, now you might deduce from that the test that they're applying is whether it's less important. I don't know. It's very difficult to tell because they don't say that. They simply say in that paragraph that incidental doesn't need to be confined to uses that are trivial. It can capture uses which are secondary or less important.
Just to be clear, how far do you disagree with this? Do you accept that something that is important can nevertheless be incidental?
I don't think I would accept that, no.
But going back to the example you gave right at the outset, it's important that we take notes of your argument in order to enable us to write the judgments.
It may be, yes.
Right, otherwise...
You're absolutely right, Lord. because there's a requirement of the being a part of, then you could say it was important, yes. As long as you're applying that criteria, then you're right. You might. It doesn't really matter whether you say it's important or not.
Something
Absolutely right.
that is important could nevertheless be carried out in order to serve some other purpose. Going back to the Vice Chancellor's
as long as you're applying that, yes. I think my confusion is that if you were not applying that test, if you were applying a sort of weighing up test or size, then I would say you can't say it's important.
Your whole
Something
point...
that's important can't be incidental on that basis.
Your whole point is this is not an exercise of ranking things in order of importance.
No.
This is a question of whether one thing serves another.
Exactly.
But that if one thing serves another, it may be a very important aspect of it.
Yes. But if you're not applying that test, if you're trying to apply incidental in a different secondary meaning, then I would say something that's important is not incidental in the secondary meaning of incidental, which is something that's quite minor.
Or to go back to another example you gave at the outset, suppose you have a vessel which is used to provide heavy lifting, and for that purpose it's moored alongside a platform, and 50 workers from the heavy lifting vessel every day go over to the platform to do the heavy lifting. They have to sleep somewhere. If there's no space for them on the platform, they've got to sleep on the heavy lifting vessel. But you say that's just part and parcel of doing the heavy lifting. Is that right?
I would say, I'd say in that case, they would be furthering the uses.
Yes, that's right. But the fact that they have to have somewhere to sleep is important, because otherwise you'd have to fly them in and out by helicopter every day.
Yes. Well, the fact that they sleep on the heavy lifting vehicle, heavy lifting asset, would not disqualify it.
Yes. But it would still be important.
It would still be important, yes.
I mean, one feature here is that the Total personnel sleeping on the Borgsten, whatever it's called, Borgsten, are not involved in providing the TAD services.
That's right.
So, in effect, the FTT is not explaining the manner in which they are incidental to anything that's going on the Borgsten. The Total personnel who work the Dunbar.
I would, that would be my suggestion.
That there's no link at all between what they're doing and what the Borgsten does.
they don't appear to require there to be any link.
Well, they don't exactly. And that, I mean, is that the error?
That is the error, exactly. Yes.
So it's not to do with how important or how essential or whatever it is. That there's simply no link.
Exactly.
So
Yes, that's a primary now, overwhelmingly
yes. No, I
primary
follow that.
solution.
So that applies. I know you haven't got onto 176, but that applies both to the TAD services and the accommodation for the Borgsten's crew. The accommodation for the Total personnel may or may not be less substantial in value or whatever than those things, but the accommodation for the Total personnel is not in fact furthering either the provision of the TAD services or the provision of the accommodation for the Borgsten crew.
Yes, yes, exactly. And the First-tier Tribunal do not say it does.
Yes. So in
This is what
thinking
address
about
that.
whether something's important or something's essential, in that sense, are we running the risk of thinking is it essential to the running of the Dunbar, which is not the question that we're concerned with.
Exactly. Yeah.
It's obviously essential to the running of the Dunbar, but that's neither here nor there.
Yes. And it's essential for, I think my friend puts it in the skeleton, it's essential for the drilling programme, or the drilling
As a whole.
as a whole.
But actually, if it's completely immaterial to the status and operation of the Borgsten, whether Total Dunbar people sleep there or sleep on some other structure.
Yes. In a sense, it's the other way around. That there are services being provided to them by the Borgsten of food and whatever.
Yeah, it's of interest to the people on the Borgsten because they need to know how many people to make breakfast for, but that's not what we're interested in.
Exactly. And what the problem is, we then have, as I said, rather a sort of with one leap they're free. They simply say, having considered all the evidence, we are satisfied on the balance of probabilities, and then they recite the statutory test, it's reasonable to suppose, etc. So it's really very difficult to tell, impossible, I would submit, to tell exactly what process the First-tier Tribunal went through. They disavowed it being a process of weighing the factors in paragraph 175, or at least they said it's not, doesn't require us simply to weigh them against the factors. All they've told us is that that's their conclusion on the evidence. So yes, just to be clear, we would say they had to address the question of whether it was used for, whether there was a link between the two, as we discussed. That's what we say is the primary meaning. But if simply saying as a secondary, if you're applying some kind of test of size, then you cannot say that something is incidental if it's important in this way, because it's just not a natural meaning of incidental. And it cannot be what was intended, because if you think about it, you then have to have some kind of exercise like this in relation to all of these craft, because it must, if it is really a question of fact that the tribunal can decide in this way, then any tribunal could decide it any way. I mean, they could decide it the opposite way, and it would have been equally, if equally a correct decision. It cannot be intended that this test was going to require this kind of level of determination. It is much simpler than this, really, we would say. It's a test that can be applied without having to look at a massive detailed investigation of all the facts and weighing them up, or not weighing them up, whatever you're doing.
That is fair, is it? I mean, the word incidental is sufficiently vague that one might think that whatever meaning one attributed to it, there would be scope for argument.
Well, there wasn't as much scope for argument if you apply the meaning that we give it, because it should be obvious in most cases whether there is that relationship. So incidental in that sense is not as difficult to determine. Just as in Robson Dixon, it wouldn't have been difficult if they had known that the Vice Chancellor's approach was the right one. It's easy to apply. Whereas if it was wrong, you would have had to weigh up the significance of the different flights, presumably, in the way that the taxpayer was arguing for in that case.
Right.
And just, I mean, I think I probably...
You want to take us to the Upper Tribunal?
Yes, I certainly can, but as I said...
And I understand the emphasis, but
Yes.
Is there anything, well, when I say it was a genuine question, do you want us to take to the Upper Tribunal?
Well, we say the Upper Tribunal was wrong because the First-tier Tribunal was wrong. Therefore, they should have reversed it. I'm not sure that it helps to analyse, where they went wrong.
Well, only if there's some significantly different analysis in your perception. You see it as just an endorsement.
It is, yes. And as I understand the First-tier Upper Tribunal, they did think they did think that the First-tier Tribunal were applying the kind of test in Robson and Dixon. That's the way that they seem to explain it. Although they distinguished the precise terms in Robson and Dixon at paragraphs 72 to 74. They did say at the end of 74, we agree that the test does incorporate a relational or relative element in the sense that use for accommodation must be incidental to some other use. And then they said they didn't make an error of law in stating it was subordinate or secondary. The element of subordination, not the same as merely identifying anticipated uses and ranking them in terms of importance. It's not the same as a main or primary test.
That's 75, is it?
That is 75, yeah.
So 76, you don't exactly quarrel with because you could accept that something could be important and nevertheless incidental. But you're going back, I'm taking you back to old ground, you've explained that.
So I think it's right to say that they thought that subordinate had this kind of flavour, even if not exactly what the Vice Chancellor said in Robson and Dixon. They thought it had some kind of relational flavour.
Yes.
But I think all that they then went on to do was to say, well, was the decision justified on the facts, rather than addressing the question of what were the FTT actually doing. My final point is this on the approach of the First-tier Tribunal, which as far as I understand it, there does seem to be scope for the legislation not giving the relief that it was intended to. Because you might have a situation where the uses to provide accommodation are merely only incidental in the sense that I've described, but are not incidental, applying the approach of the First-tier Tribunal and weighing up some way the relative importance. We say that approach shouldn't be adopted at all. It shouldn't be there, because it would have the possibility that a situation where it was just the crew of the support vessel, but there were offshore workers amongst them, could be held not to be incidental because it was sufficiently important. think they've lost a lot of work due to immigration, some changes in immigration procedure. I was told. I don't know if you noticed, but we seem to be getting decisions really quickly in our Court of Appeal. All the decisions in the last year or two are gone, and within weeks, a few weeks.
Before you even open your mouth.
Well, that's possibly true.
Check the metadata.
They used to be quite slow. But
Yeah.
great development. They shouldn't reveal that. They should,
It's outrageous.
and they get rid of it.
Yeah. I think there's software that does that, that strips all the metadata out.
Yeah. No.
Yes, Mr. Shaw.
So what it is reasonable to suppose about the likely uses of the Borgsten, and in particular, whether its use to accommodate offshore workers was unlikely to be more than incidental, is, we say, ultimately an evaluative question for the FTT, unless it can be shown that the FTT misdirected itself. And in our submission, none of the grounds of appeal reveal any such misdirection. The Revenue's first ground of appeal concerns the meaning of the words incidental to, and in our submission there is nothing special or complicated about those words. They should simply be given their ordinary meaning, and the ordinary meaning, according to the FTT and the Upper Tribunal, is secondary or subordinate to something else. And we would respectfully endorse that definition. We would also respectfully endorse what the Upper Tribunal says in paragraphs 73 to 75 of its decision, that whether one thing can be said to be incidental to another thing involves a qualitative assessment of the relationship between the two components, and that it is not simply a question of identifying the main or primary use or the most important use, to which all other uses must then be regarded as incidental. And so that is why we say the FTT was correct to say that the test in section 356 LA3 is not the same as a primary or main purpose test, because it does not follow from the fact that one use is identified as the primary or main use that any other use is incidental. And so take, for example, a round-the-world racing yacht. In my submission, the primary use of a round-the-world racing yacht is for sailing. Its other uses would include sleeping, washing, and preparing meals. Those are not incidental uses, however. They are integral uses to the use of the yacht as a round-the-world sailing yacht. Similarly, we say the primary use of the Borgsten was to provide TAD services. Another use of the Borgsten was to accommodate its own crew, but that was not an incidental use. It was integral to the use of the Borgsten as a TSV. And
You're using integral as a, and I quite understand why, as it were, as a contrast,
a counterfoil, exactly,
a
yes.
counterfoil to incidental.
Yes.
I'm afraid I didn't, as I said, Dan, I didn't keep up with you. So another use was to accommodate its own crew, and then I missed your next words.
So the primary use of the Borgsten is to provide TAD services. Another use is to accommodate its own crew.
Yes.
So you might say, well, that's a second use. But the fact that it is a second or a secondary use does not make it incidental. It is an integral use to the use of the Borgsten as a TSV. And that, in my submission, is why the Upper Tribunal considered that the more critical element is the element of subordination.
Can I just think about that one moment? So you say the primary purpose of the Borgsten was to provide the TAD services.
Yes.
To provide the TAD services, they needed to accommodate their crew.
Yes.
So why wasn't the accommodation of the crew incidental to the provision of the TAD services?
Because it's integral to it. You cannot provide it's not an incidental use, accommodating the crew. It is something which is necessary in order to provide the TAD services.
Can I go back to your yacht example?
Yes.
The main use of a yacht is to sail around the world. And
Yes.
that's what it's there for. In order to do that, the people on board have to sleep and eat and wash and do everything else.
Yes.
But why is that not incidental to the main purpose, which is to sail around the world?
Well, as I said, because that is integral. You cannot sail around the world unless you can put your crew up somewhere and allow them to wash and allow them to prepare meals and so on. Those are other uses which are, well, to use Sir John Pennyquick's expression, they are coordinate. They are of the same rank, if you like, as the use to sail.
So they are part of the use. When you say they're integral, you mean they are part of that use.
Yes, they are. You're looking for well, components, and all of those components are necessary, are integral to the overall use of the asset. Whereas in my submission, the words incidental to are asking you to identify another use which, in relation to another use, is
Well, if you
minor.
needed, for example, I mean, I know it doesn't particularly fit with a racing yacht, but if on a vessel you needed to take on at some point a pilot because you had a very difficult crossing, if you're going through the Panama Canal or something like this, you need to take somebody on. Well, clearly having somebody on board for that purpose is incidental to your sailing purpose.
Exactly. That's a good
Whereas
example.
you being on your own boat sailing around the world can scarcely be described as being incidental to the sailing purpose.
Exactly.
It's what it's for.
Exactly. It's those other uses have the same quality or nature. They are the same. They rank the same, even though they are. The majority of the use is to sail rather than to sleep, and often on these races you might only catch 2, 3, 4 hours of sleep at a time, or you might prepare a very quick meal and so on. So those other uses are smaller, but they are not incidental. They are integral to the.
So what I mean, just coming. I know you're developing your case, as it were, but at some point, what link is there between the presence of Total personnel on the Borgsten to the uses of the Borgsten? What link is there at all? So one even gets to thinking about whether it's incidental or integral.
Well, the purpose of the TAD services is to enable the drilling campaign to be carried out. So without those TAD services, the Dunbar is not capable of drilling.
But we're not talking about the relevance of the Total personnel to the services provided by the Borgsten. We're talking about the relevance of the Total personnel to the Borgsten.
To the use of the Borgsten, yes. So the primary use of the Borgsten is to provide TAD services. And what that does is to facilitate the drilling campaign on the Dunbar. And as a consequence of that, all the people working on the Dunbar are required to be on the Dunbar and then need to be accommodated. So the link is that, but for the TAD services, there wouldn't be anybody working on the Dunbar, and therefore there wouldn't be anybody requiring accommodation. That's the link between.
No, but I mean this but-for test, which I saw had come in elsewhere in the arguments in the other courts, that's surely not the point at all. I mean, what difference does it make to the provision of TAD services by the Borgsten as to whether these people are sleeping on your rig or sleeping on a flotel next to you?
Oh, it doesn't. That doesn't make any difference. No, I mean that's they could. That's the point the Upper Tribunal makes, is that they could have been accommodated on a flotel. No doubt.
And your TAD services would have continued uninterrupted.
And the TAD services would have continued, yeah. But
in that case, in what?
they're not necessary. My case is not that they're necessary for the TAD services. I am saying that the need for accommodation for certain of the Dunbar personnel, I'm going to come on to this, in large part, the accommodation of Dunbar offshore workers is a matter of preference for Total. Yeah. Secondly, it's a matter of efficiency, because there was certainly no finding of fact that the Dunbar needed to have 80 workers on it. It was all to do with speeding up the drilling campaign. So it was an efficiency rather than a necessity. So there wasn't actually any need for the Dunbar workers to be accommodated on the Borgsten.
But there was a need for some of them to be accommodated other than on the Dunbar.
There was a need because Total had staffed the project with more personnel than could be accommodated on the Dunbar.
So just as you needed the TAD services for the drilling campaign to proceed, you needed accommodation for some Total personnel not on the Dunbar for the campaign to be pursued as it was.
Yes, because Total had chosen.
Does it matter whether it's a matter of choice? I mean, in a sense, the whole thing's a matter of choice. They needn't have started drilling in Dunbar at all. That was a matter of weighing up the economics of how much it will cost to restart the platform and how much they expect to get from it. And so this is a commercial decision by Total. The way we want to do this is to have 80 people working on our platform in the pre-drilling phase and in the drilling phase to get there as quickly as possible. Once they've made that decision, because there's only 60 berths on the Dunbar, they do need somewhere for the other 20 people to sleep every night. And as my lord said, it doesn't need to have been on the Borgsten, it could have been on something else. But there was a need to accommodate Dunbar workers other than on Dunbar, given the way in which Total decided to run their contract.
Yeah, sure. But obviously the third of the revenue's grounds is that it was essential, and if it was essential, then it couldn't have been incidental to. So
I mean, I rather think that Mr. Ewart might be disavowing that part. He might. I'm not sure that he would necessarily say now that something essential couldn't be incidental. But at any rate, if we are concerned with essentiality, true it is that the accommodation could have been provided in some other way, but so could the TAD services. Neither was essential. I mean, the Borgsten needn't have been used at all.
I'm not sure I follow that point.
Well, if the hypothesis is, look, there was no need to use the Borgsten to provide the necessary accommodation, it would have been possible to have a separate vessel. Well, there was no need to use the Borgsten to provide the TAD services either. I mean, there was always a choice to use something else. But what actually happened was that Total wanted a package comprising TAD services and accommodation. That's what it contracted for, and it got both through the Borgsten.
Why do you say that the Borgsten wouldn't have been used at all? Because
well, they didn't have to. They could have opted for some different vessel that only provided TAD services and some different vessel that only provided accommodation.
Well,
but they needed both functions.
Well, they needed the TAD services, and the FTT finds that if they hadn't needed the TAD services, they would have simply chartered a flotel. So what was driving the charter of the Borgsten was the need for TAD services.
Well, I mean, I'm not sure the subjective views matter, but they put out to tender a package comprising both. They wanted both.
They wanted both, absolutely, but my point is that the accommodation was more of a nice to have than an essential requirement. So there is no finding anywhere that said if the Borgsten had not had surplus accommodation, then it was a no-go. There is no finding that says in order to complete or carry out the drilling campaign, Total had to have 80 personnel during the pre-drilling phase and 60 to 70 personnel during the drilling phase. So
I still have difficulty with this idea that it makes any difference that Total might have been able to do their pre-drilling with only 60 people. The fact is they wanted to have 80 people.
absolutely.
Well, once they've decided they want 80 people, they do need to have accommodation. They paid a lot of money to put extra accommodation on the Borgsten. And so they obviously made that choice that they did need to have it. It's not just a nice to have, it's something they wanted. If they wanted for it and they contracted for it, and they paid, I think it was $4 million to have it put on the Borgsten, it's very difficult to say that it's just a nice to have. It's something they wanted and something that, as my lord said, they tendered for and something they contracted for.
Absolutely, but it's not a deal breaker. There's certainly
But
no evidence that it is a deal breaker.
Well, I understand that there isn't a finding that they couldn't have done it with only 60 people. Maybe they could have done it with only 60 people. Maybe the economics just wouldn't have worked with only 60 people. We don't know, but I don't myself see it's relevant whether they could have done it some other way. This was the way they chose to do it. Once they've chosen to do it this way, I have great difficulty in seeing why accommodation on the Borgsten wasn't an essential part of what they were getting. Because that's what they needed in order to do it that way. Am I wrong in thinking that it's irrelevant whether they could have done it a different way? The fact is they chose to do it this way.
For sure, it depends what you mean by essential. Yeah, if you say, well, this is what they wanted, and in order to get what they wanted, this is what they needed, well, then that is one meaning of essential then. I mean...
Well, can I put it as simply as this? Once they've decided they want 80 people working on the Dunbar on any one day, they need accommodation.
For 20.
For 20.
Yes.
Yes.
Could we just... I asked a question a moment ago about what link there was between the presence of these folk on the Borgsten and the TAD services. Now, the TAD services are helpfully summarised in paragraph 26 of the FTT judgment,
yes,
in those 3 paragraphs. And what I haven't understood is what the presence of these accommodated folk has got to do with the provision of those 3 TAD services in any way whatever.
So the TAD services,
yes,
in a nutshell, enable the drilling to occur, because without those services, they lubricate the drill bit, they enable the drill to run, essentially, and then there's analysis and various other components to it.
I understand it, but when looking at the 3 things, it seems to me that the sleeping accommodated folk have got nothing to do with the TAD services that are being provided. Nothing at all.
Well, they're not carrying out those
No, but they haven't
services.
got in, in a sense, they're there and they're doing what they do on the Dunbar. They sleep on the boat.
Yes, but they are only there because of the TAD services. The offshore workers are only there because of the provision of the TAD services.
No, but that's not the test. There's no link. There's no relationship between the presence of the accommodated people and the purposes that are being carried out by the other purposes that are being carried out by the rig.
Well, the revenue put it that what incidental to means is something that arises as a natural consequence of something else. So,
But their presence on this rig is not, doesn't arise if you take that test. It doesn't arise in consequence of the provision of the TAD service, because they could be in any number of other places. The fact that they're on this particular rig is entirely irrelevant.
I'm not sure that Mr. Hewitt this morning, that different tests have been put forward at different times. I don't understand Mr. Hewitt this morning to be pinning his colours to the mast of natural consequence. He's pinning his colours to the mast of, is it carried out in order to further another purpose? If I've understood it correctly.
well, he describes that as, if you like, the other side of the coin in his skeleton argument. He says to put it another way.
But at any rate, as it opened to us this morning, he says, well, look at the Vice-Chancellor. Is it carried out to further another purpose? Were that the test, he wins, does he? Because the Total personnel are not provided accommodation to further either the provision of the TAD services or to further the provision of accommodation for Borgsten's crew.
Well, they are furthering the same purpose, though, because the purpose of the TAD services is to facilitate the drilling campaign.
All three things are there to further the overall purpose.
Yes.
Can I just, we've led you into dealing with the particular facts. Can I just take you back? You were, after dealing with your round-the-world yacht, you started to say, and I noted down this, and you can tell me if I've got it wrong, the words incidental to are asking you to identify another use which in relation to the first use is minor. Is that your case?
Yes. Secondary, subordinate, or minor.
But they're not the same thing.
Well,
I mean, minor
we
minor
have
has
to
a
give meaning to the words
but
incidental to.
But if you mean secondary and subordinate mean minor, then that's one thing. If you mean they are of lesser importance, that's another thing.
It's very hard to be prescriptive because the words themselves are not prescriptive. And so the danger of trying to overly define the test is going to lead you into well, precisely the sort of criticism that the revenue make and which we're all now grappling with as to exactly what the meaning is. And that is why I opened by saying it is ultimately an evaluative question. It's a feeling, if you like.
It's an ordinary English word, and that is what evaluating it is the exercise of the first-tier tribunal. But to pick up my Lord's point, there is a real difference, which is a difference of principle between saying incidental can be glossed as minor, which is a question of, to use Mr. Hewitt's phrase, sizing. What's more important? Where does it rank? And subordinate in the sense of it's in a secondary relationship to something else, and or to use the Vice-Chancellor's word, it's furthering some other objective. And if it means that, that's not the same as just simply whether it's minor or not. As the Upper Tribunal says, it's about the quality of the relationship between two things.
Yes.
And my Lord Peter Jackson has asked, well, what is the relationship between accommodating the Total personnel who are working on the Dunbar, but who I think you accept aren't providing the TAV services, they're operating the rig. What is the relationship between that purpose, accommodating those people for 50 or so a day, and the other purposes to which the Borgsten is put, which is providing the TAV services?
Yeah, and I said the relationship is the drilling campaign.
Yes,
They're both in support of a drilling campaign.
Yes, the overall purpose is the way you put it.
Yes.
Wasn't it?
No, I think I understand. Yeah. I understand that.
Yes, I understand that. I wonder, once my Lord has asked his question, this has been very helpful.
Yeah, it has been very helpful.
But we'll then quieten down and let you develop the argument in the way that you'd like.
That seems very fair, but can I just ask this question? So can I come back to my car park example to
Yes.
understand where you stand in relation to that. So I put up an office building, I allocate 20 spaces in the car park to one office and 30 spaces to another office. Now, plainly the provision of the 20 doesn't serve the provision of the 30. But as you've explained, your position is not that one must serve the other, but that one must be minor, secondary, subordinate in some other sense. So would the provision of the 20 be incidental to the provision of the 30 on your case?
No, it would be incidental to the use of the office to which those 20 spaces relate.
So when the tribunal contemplates that the provision of accommodation for Total personnel might be incidental to the provision of accommodation for the Borgsten crew, they're wrong about that?
Well, as I read what the FTT is saying there, is it's identified the two uses of the two other uses of the Borgsten, namely the provision of the TAD services and the provision of the Borgsten's own crew. I mean, a third use would be the accommodation of Total personnel who work on board the Borgsten. But it's essentially saying that those are the other uses, and what we have to ask ourselves is the use of the Borgsten to accommodate offshore workers incidental to one of those uses or all of those uses? And it doesn't really much matter which, so we're just going to say and or. I don't think
I follow that, but is the provision of accommodation for the Total workers capable of being incidental to the provision of accommodation for the Borgsten crew?
Well, on the revenues interpretation, presumably it is, because the purpose served there is to provide crew, personnel, workers with accommodation.
Well, I think Mr. Ewart would say, well, the provision of accommodation for the Total personnel doesn't further the provision of accommodation for the Borgsten crew. But leave aside what Mr. Ewart would say. What do you say? Do you say that the provision of accommodation for the Total personnel is capable of being incidental to the provision of accommodation for the Borgsten crew?
I wouldn't say that, viewed in isolation, no.
Yeah.
Right.
Okay, so shall I turn to my script? Okay, so there are two aspects to the revenue's first ground of appeal. First, it said that the words incidental to require a causal link between the two components in order for one to be incidental to the other. And certainly in their skeleton argument, that is put in the alternative way as being the supposed incidental element must not serve an independent purpose. It must be there to further the purpose of the other element or elements. And the second aspect is that on the facts of the case, the Borgsten's use in accommodating offshore workers wasn't a natural consequence of its use in providing the TAD services, or as it's alternatively expressed, had an independent purpose of substantial importance and value. And in our submission, neither of those propositions is correct. So starting then with the proposition that there must be a causal link, in our submission, the words incidental to don't prescribe any particular kind of relationship between the components. We say that something can be incidental to another thing if it arises in connection or in relation to that other thing. What is required is a relationship, but it doesn't need to be a causal relationship. So we say that the words incidental to are not restricted. They may involve, but they're not restricted to things which arise as a natural consequence or as a result of other things. And can we please return to Robson and Dixon, please, which is in the authorities, tab 2, page 15. So at letter B there, the Vice-Chancellor explains that the taxpayer's UK duties were not incidental to his foreign duties, they were precisely coordinate with them. And we would say that what the Vice-Chancellor means by coordinate there is of equal significance or ranking or importance. In other words, landing and taking off at Heathrow is not subordinate, it is the same as landing and taking off at Schiphol or any other international airport. And then the example between letters G and H of the emergency landing due to poor weather conditions or mechanical trouble, he does regard as clearly incidental to the performance of the foreign duties. And what's interesting about that example, we say, is that the cause of the emergency landing is not the foreign duties, it's the mechanical failure or the poor weather conditions. And yet, notwithstanding the absence of a causal link, the Vice-Chancellor regards the emergency landing as clearly incidental to the foreign duties. And we say that he's right to regard that as clearly incidental, because on any view, performing an emergency landing is a minor or less significant component of a pilot's duties to the core duties of a pilot. And it's also a good illustration of the point which the FTT and the Upper Tribunal make, which is that desirable, sought after, or important components may nevertheless still be incidental, because undoubtedly an emergency landing is of the utmost importance. And then Robson and Dixon also illustrates why the incidental to test is not simply a case of identifying the main or the most important component, to which all other components must be incidental, because we looked at the particular facts of the case a moment ago, but of the 811 takeoffs and landings, only 38 took place in the UK and were for periods of 1 hour or less. So plainly on the facts of Robson and Dixon, Captain Robson's duties were mainly carried out overseas, and yet that was not sufficient to make his UK duties incidental to those foreign duties. So we say that contrary to what the Revenue contend in paragraph 28 of their skeleton, there is plainly a meaningful distinction between a test based on the words incidental to and a test based on the words primary or main. It's not enough just to show that one use is the primary or main use. And then finally, before we leave Robson and Dixon, if we go back to the paragraph at the bottom of page 14, just at letter H, the expression merely incidental to is a striking one, and effect must be given to the natural meaning of those words. The words merely incidental to are, upon their ordinary use, apt to denote an activity, here the performance of duties, which does not serve any independent purpose, but is carried out in order to further some other purpose. Now, in our submission, what the Vice-Chancellor is trying to grapple with here is the significance of the word merely. And he's trying to understand what additional quality above and beyond the words incidental to that word merely is intended to convey. And what he takes it to add is that the UK duties, or the incidental component, must have no separate or freestanding objective. Now, in this case, we're not concerned with that same language. And we say, contrary to what is said in paragraph 29 of the revenue skeleton, the words unlikely to be more than in 356 LA3 are not equivalent to the word merely in section 11 of the Finance Act 1956. We say the words unlikely to be more than are simply a product of the negative formulation of the test. Then,
what would a positive formulation be?
so a positive formulation would be if it is reasonable to suppose that its use to provide accommodation for offshore workers is likely to be incidental to another use or other uses.
But that doesn't mean the same thing. For it to mean the same thing, you have to put in merely.
Why?
Because it has to be no more than incidental. Your reformulation doesn't capture the no more.
Well, my submission is the words no more are there in order to formulate it in a negative fashion. You can't, if you were to try to take out those words but keep it as a negative, unlikely.
You can substitute only, but if it's incidental and something else, then it has to be no more than incidental.
But only because you've got the word unlikely in there. It's a negative formulation.
But it could, well, why is it different if you say likely to be only incidental or likely to be merely incidental?
Well, because in my submission, it was the addition of the word merely.
But just come back to this. Why would it be different in meaning to say likely to be just incidental, likely to be only incidental, likely to be merely incidental? Why would that be different in meaning to unlikely to be more than incidental?
Well, my point is simply that you can, what we don't know is whether Parliament intended the addition of the word merely. The revenues say, well, no more than equates to merely. But my point is, you can't deduce that just from the language of 356 LA3. Those words are necessary in order to articulate the test in a negative way, and it is possible to reformulate it in a way that doesn't make any use of the word merely or only or simply or...
So in your reformulation, you say likely to be incidental.
Yes.
On that basis, if it's incidental and something else, that's all right, is it?
I'm not sure I follow the point. So
well, what's the difference between incidental and merely incidental?
Well, so what I would say the Vice-Chancellor is getting at here is that the word merely is adding this purpose component, if you like. So something is merely incidental, where in order to be merely incidental, it must pursue the same purpose, whereas something could be incidental to something else, regardless of whether it pursues the same purpose. And in fact, I would say in Robson and Dixon, the Vice-Chancellor doesn't even get on to the question of whether it was merely incidental. He doesn't have to, because he's already concluded that the duties aren't incidental. If they're not incidental, then they can hardly be merely incidental.
Yes.
But he decides that without reference to any component of whether they pursue the same purposes or not. And actually, clearly, the UK duties do pursue the same purpose as the foreign duties. They're all concerned with getting passengers from A to B. So,
but on the Vice-Chancellor's test, that doesn't do it. The question would be whether the UK duties further the foreign duties.
Absolutely, but again, he's not here referring to. He moves on from this the additional component added by the word merely. Take the example of the emergency landing. I would say that clearly serves a different purpose. It's about averting a catastrophic.
I mean, he may have in mind that incidental can mean both things, either A, furthering another purpose, or B, minor, trivial.
Absolutely. Well, and that essentially is my case. It can mean both of those things. And
but minor, trivial is not the same as less important then.
No, it's not just a case of importance will be one factor. This is a multi-factor evaluation. But for the revenue to get home, they have to say this narrow meaning of the words incidental to is the one that Parliament intended.
Yes.
In my cases, there is no basis for a narrow interpretation. Incidental to can mean both of those things, all of those things. It requires a relationship, not necessarily a causal relationship. Something can be connected with or relate to in a more amorphous sense and still be incidental to it.
Yes.
Like the emergency landing. So on the question of whether a narrow, particularly narrow interpretation is warranted here, the revenue put forward two contentions in support of that proposition in paragraph 30 of their skeleton argument. They say that a narrow interpretation is consistent with the purpose of 356 LA, and they say that a narrow interpretation is justified on the basis that subsection 3 is an exception to a charging provision. And in our submission, neither of those propositions is sustainable. Firstly, we say that the purpose of 356 LA is to define what is meant by relevant assets. And as the FTT correctly observes in paragraph 163, it was Parliament's intention that this term be limited to drilling rigs and accommodation vessels. Now, on any view, it is not a natural description of the Borgsten to describe it as an accommodation vessel. Secondly, we say subsection 3 is not an exception to a charging provision. It is an additional component of the definition of relevant asset. And specifically, it is a qualification to 356 LA 2B2, the definition of accommodation vessels. And the purpose of subsection 3, as the Upper Tribunal correctly observes in paragraph 67, is to limit the types of accommodation assets caught by the cap by carving out vessels which can be used to accommodate offshore workers where that use is likely to be incidental. And thirdly, we say that even if subsection 3 is properly to be regarded as an exception, it doesn't follow from that that it is to be narrowly construed, And I want to just very briefly show you the decision of Lord Justice Chadwick in Expert Witness Institute, which you may be familiar with. It's a VAT case, and I'm so sorry, it's in the supplementary authorities bundle. We might have a copy of it.
No, I really don't need it. If
You don't?
you're going to tell us what it says.
Okay, wonderful. So, Expert Witness Institutes at tab 3, page 17. This was a case concerning the meaning of the word civic in item 1E of Group 9 to Schedule 9 of the VAT Act, which provides an exemption from VAT in respect of services supplied by to members by bodies with objects of a civic nature. And the question was whether the Expert Witness Institute was such a body with objects of a civic nature. And if we can pick it up on page 26. In the centre of paragraph 16, the judge sets out there the well-known passage from the Court of Justice about exemptions from VAT being strictly construed because they constitute exemptions from VAT. And then in paragraph 17, he says, it does not follow, however, that the court is required to give to the phrase aims of a civic nature the most restricted or most narrow meaning that can be given to those words. A strict construction is not to be equated in this context with a restricted construction. And you can see that he goes on to explain that what's required is a fair interpretation. And then he goes on to illustrate the point by reference to the dictionary definition of the word civic. And over the page, after that dictionary definition, he says, no one could suggest that a non-profit making organisation with aims of a civic nature in the context of the VAT exemption meant only a body, if one could be found, whose object was the distribution of garlands of oak leaves and acorns amongst those of its members who had saved the life of a fellow citizen in war. But that is perhaps the most narrow meaning which could be given to the words. And it's for that reason that he rejected the Revenue's contention that aims of a civic nature meant aims of a municipal nature rather than aims pertaining to citizenship. So in our submission, even if subsection 3 can properly be categorised as an exception, it doesn't follow that it is to be narrowly construed, certainly not as narrowly construed as the Revenue contend. And nor, we say, is there any indication in the background to the legislation to support that proposition. And my lord, you asked whether it's legitimate to have a look at these materials, and it certainly is legitimate to have a look at background materials as an aid to the construction. So if you are struggling to find the meaning of the words incidental to, then it is legitimate for you to have a look at the autumn statement and all of those background materials. But in our submission, they are simply ordinary words, and they take their ordinary meaning, and there's nothing in these background materials that we looked at to indicate anything otherwise. But if we can just briefly return to the technical note, which was at page 44, and on page 46, we've already looked at it, but you can see there that following the announcement of the proposed provisions, there was a period of initial consultation, and as a result of that initial consultation, the scope of the proposed measure was significantly pared back so as to only be applicable to drilling rigs and accommodation vessels. And then if we turn to the draft legislation itself on page 51, you can see there that it was in very different terms in its draft form, and in particular the definition of an accommodation asset was an asset that can be used to provide accommodation for individuals who work on or from a structure. So, and what that is doing is catching every single support vessel with any accommodation on it. It's nothing to do with accommodating offshore workers. It's anyone working in the North Sea who is accommodated on a vessel, the vessel would be caught. And then obviously there's no subsection 3. The subsection 3 is not the one that we're dealing with. And then if we jump down to page 66, in paragraph 68 at the bottom there, you can see that the revenue throw this out for further period of consultation. Responses by the 9th of May 2014. And it was following that consultation that the hire cap was again further pared back so as to so we say that what all of this is showing is that the hire cap was intended to be of narrow application, not subsection 3 intended to be of narrow application. And
well, it's as my lord said this morning, it's very interesting seeing all this material, but I do have doubts as to whether the evolution of the text is something that is admissible strictly on a question of construction. I understand entirely that background papers are admissible to illustrate the mischief at which legislation is aimed.
yes,
So we can look and see the general purpose of this is to capture profits which were thought of being offshored in a way that was unacceptable to the government.
yes.
But the detailed evolution of a proposal, a draft, and the text of the legislation that emerges, are we able to look at that?
Well, I mean, it's just general background, isn't it? I mean, either it's serving a purpose of helping you to interpret the legislation, or it's just part of the general background. But to respond to my learned friend's point, which is what this shows you is that a very narrow interpretation of subsection 3 should be adopted. I say you don't get that from this material. In fact, you get the opposite.
I see. Thank you.
And then finally on the meaning of the words incidental, we illustrate in paragraph 16 of our skeleton that if Parliament had intended the words incidental to be read as meaning a natural consequence of, then we say that it would have formulated the test in a different way, because something is either a result or a consequence of something else, or it isn't. It's not a question of degree. What the words "no more than" would tend to suggest is that it is a question of degree, and that in our submission points you towards a more natural interpretation, which is looking at something which is of less significance, a minor component, that sort of what I would say is the other meaning of the words incidental to. So for all those reasons, we say that the FTT and the Upper Tribunal were correct in interpreting the words incidental to as meaning secondary or subordinate to, and having correctly construed the statutory test in our submission, it was then an evaluative question for the FTT as to whether or not the use of the Borgsten to accommodate offshore workers was unlikely to be more than incidental to its other uses. And that is not an exercise which can be challenged before this court, other than on Edwards and Bairstow grounds, which the revenue rightly do not raise here. So that is sufficient to dispose of ground 1. But in any event, we say applying the revenue's narrower interpretation, none of the factors relied upon by the revenue in paragraph 32 of their skeleton, either collectively or individually, suggest that the use of the Borgsten to accommodate offshore workers was anything other than a natural consequence serving the same purpose as the provision of TAD services. So the first factor relied upon is that the Borgsten had surplus berths, and indeed that the number of surplus berths was subsequently increased at an additional cost of £4 million. And we make 3 points in response to that. First, we say the fact that the Borgsten had surplus accommodation is relevant to subsection 2b2. It is the reason why the Borgsten was capable of being used to accommodate offshore workers, but it's not in our submission informative of subsection 3, which is whether the use to accommodate offshore workers is unlikely to be more than incidental to the other uses. Our second point is that all support vessels have surplus accommodation. That's the FTT's observation at 63 and 173.1. And the expectation is that the operator will be able to make use of that surplus accommodation to accommodate its own personnel. So we say if the mere fact that the Borgsten had surplus accommodation is sufficient to bring it within the hire cap, then all support vessels would be caught by the hire cap, and subsection 3 would have no practical application. And the third point, as the FTT correctly concludes in 172.4, is that the significance of the expenditure incurred on increasing the amount of surplus accommodation has to be viewed in context. So, of course, it's right, Total did spend £4 million, or $6.7 million, on increasing the amount of surplus accommodation, but that was a minor expense in comparison to the $45 million that it paid for the Borgsten to be converted into a TSV and for the acceleration of the class renewal certificate, which enabled the drilling campaign to continue uninterrupted. And that's the FTT's findings at 34 and 98. In addition, the Upper Tribunal observed in paragraph 84 of its decision, where it refers to the FTT's decision at 113 to 126, that the reason why Total wanted the additional surplus accommodation was in order to begin drilling more quickly. And so in our submission, the accommodation of offshore workers is a consequence of the provision of TAD services, because without those TAD services, there would be no drilling campaign and there would be no offshore
This is your but for.
Workers, exactly. That they both the accommodation of offshore workers and the TAD services point towards the same goal, which is the drilling campaign. So we say, on any view, the use of the Borgsten to accommodate offshore workers was not a separate and independent use. It was a consequence of the provision of the TAD services. We're at 1 o'clock. I've got a bit more I need to move through the remaining factors.
By all means. What sort of estimate have you got in mind?
Maybe another 40 minutes.
Thank you. Thank you very much. Very well. We'll resume at 2 o'clock.